both the complaint and whereunder the decree holder made an allegations regarding the alleged interference of the judgment debtors with his supporters in and decree passed in OS number so and so. In the first complaint that has been forwarded to SP Davangere, the decree holder number 2 has made an allegation that the judgment debtor, that is Raju son of Siddappa, Lokesh son of Siddappa, Chikkappa son of K. Siddappa and other two ladies were trespassed into they what they are, the learned say, judge is saying that we are the supporters of the judgment debtor, but your lords may kindly appreciate that we are the co-personers of the judgment decree executing court, that we are the supporters.
Or even take that you are an co-owner of the property.
Yes.
Now there is a decree.
Decree is there, but behind the back of our knowledge, without there being any such hearing of us, it is a failure of principles of natural justice.
Two things, Mr. Injunction is against that particular persons.
Yes.
It is operating against them person who is a party.
Allah, my title deed is based on partition deed. That is
Madam,
proved, my
right,
lord, in
madam.
the.
Injunction can be filed against that person who is interfering there. It can be implemented only against that person.
Yes, ma'am.
Suppose if you are aggrieved that no, it is affect you, you have to challenge that decree, not in that execution.
Yes,
Execution
my
court
lord,
can't do anything.
yes, my lord, but by overall the executing court has a empower to implement the order of the decrees. I
Say,
understood.
if you say that degree is wrong without notice, you are not, without all that can be urged only in that appeal, not before that executing court. Appeal, not before that executing court.
Yes,
He
ma'am.
is not a
Thing
party in
is
the
not-
execution petition.
Not them has to be argued.
Not before the executing, but being a co-owners of the
You
scheduled
say,
property.
No, I'm not, see, if you are co-owner or you are owner, you are not party, you have been displaced, anything can be only in that appeal you are challenging that executing court, decree has been passed against who? That has to be implemented.
Against the defendant, not against the party who were not before the court, my lord.
Then why you have come before that executing court, mister? You keep quiet, let them police.
No, we have not having any such knowledge, my lord. That is my submission, my lord. We doesn't have any knowledge about
What
the
is that
decrees.
knowledge, mister?
We doesn't have, we peacefully enjoying the properties in
No,
question.
there are thousands of remedies for you. If you are in peaceful enjoyment, somebody is disturbing, go and file an injunction suit. If you are
And-
agreed by that order of the degree, you challenge the degree, not in that execution saying that I am peaceful, mister. You
Yes,
have
ma'am.
to
On
challenge
the
that.
other hand, if I am going to challenge the said judgment and decrees be in the other suit or somewhere else before the appropriate court, forthwith they are rejecting from the scheduled property, mal. That is the threat.
No, that you go and file a suit for injunction if it is affected you. If you are
After
not-
that, if it is ejected, what remains, my lord? If
No.
it is ejected from
You
the
don't know,
scheduled
mister,
property.
you can't put a question to me that what.
Yes,
they can
yes,
do.
I know, sorry.
May-
And
may-
my
ಡಿಗ್ರಿ ತಗೊಂಡ್ಬಿಟ್ಟು ಅವ್ರಿಗೆ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಬೇಡಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಕೋರ್ಟ್ ಹೇಳಿದ್ರೆ
non property, how can they
May I,
execute,
my
my
lord?
lord?
ಡಿಗ್ರಿ ಇರೋದೇ ಅದ್ರ ಮೇಲೆ
ಅಲ್ಲಿ ನನ್ನ ಪ್ರಾಪರ್ಟಿ, ನನ್ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ.
ಪ್ರಾಪರ್ಟಿ ಮೇಲೆ ಯಾರು ಡಿಗ್ರಿ ತಗೊಂಡ್ರೆ ನೀವ್ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಪ್ಪ? ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕಾ ಬೇಡ ಹೇಳ?
ಅದನ್ನೇ ಚಾಲೆಂಜ್ ಮಾಡಿ ಸುಮ್ನೆ.
ಇಲ್ಲಲ್ಲ, ಎಕ್ಸಿಕ್ಯೂಟಿಂಗ್ ಕೋರ್ಟಿನ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಅಲ್ಲ, ಡಿಗ್ರಿ ಅಪೀಲ್ ಇರೋದೇ ಅದಕ್ಕೆ ಕೇಳು.
So till then,
ನಾನೇ ಲಾಯರ್, ನಾನೇ ಅಡ್ವೈಸ್ ಮಾಡ್ಬೇಕು ಪಾರ್ಟಿ.
ಅಲ್ಲ, that is there, but thing is that the executing court wanted to implement the decrees against the party who was not before the court.
ಅದ್ರ ನೀವು ಇಮಿಡಿಯೇಟ್ ಆಗಿ ನಿಮಗೆ ಬಂದು ಪಾರ್ಟಿ ಹೇಳಿದ ತಕ್ಷಣ ನೀವು ಅಡ್ವೈಸ್ ಮಾಡ್ಬೇಕು, ಹೋಗ ಸೂಟ್ ಹಾಕು ನೀನು ಇಂಜೆಕ್ಷನ್ ತಗ ಅಂತ. ಅದು ಬಿಟ್ಬಿಟ್ಟು ಎಕ್ಸಿಕ್ಯೂಟಿಂಗ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಫೈಟ್ ಮಾಡಿದಿರ ರಾಂಗ್ ಫಾರ್ಮ್.
May I, my lord?
Yes.
If I am permitted. My lord, execution petition, my lord, is filed against one Rudresh, who is respond number 2 in the petition filed by the petitioners.
Yes.
My lord, in this impugned order, my lord, which they have challenged, we had sought for police protection. Accordingly, my lord, the trial court has given police protection to the decree holders. Now, if my lords may kindly see my IA for vacating stay, IA for vacating stay, my lord, page 6 is my
No, that
RTC and Pani.
that is all-
RA, annexure A is my.
No, Rudresh, you may be made some wrong person.
Well, I am the decree, my suit is
you-
decreed on the basis of partition deed. That is my
We know,
submission.
madam, what are going on.
Please, my lord.
You can make some persons who is suitable for you as in a party, we get it in degree.
Please, my lord.
Who is suitable for you as in a party, we get it in degree.
Please, my lord.
But if he is affected, his remedy is
No,
to.
my lord, my
just become-
submission is respond number 2.
Or not?
My lord, they
At
have,
least from the
they have
Rudresh.
suffered OS.
Mister, I am not deciding the degree.
Yes, yes.
That's
My
correct.
lord, for
But
a
at least
moment,
how they got
they
the rights
belong
over the
to,
property
they
in
belong to
question.
Kurba community and the decree holder belongs to Lingayat community. How they can be co-partner?
Madam,
ಅವ್ರದ್ದು right established.
the Order 21 Rule 97 application, he can be filed as an objector if
He
there.
can file, who can file, my lord? Law is very clear. That has to be adjudicated by the executing
Who said
court.
it is only
Your
judgment
lordships
letter?
may kindly see Order 21 Rule 97.
What is that? Read.
Please, my lord. And my lord, my suit is decreed on the basis of partition
To
deed.
answer first that
Please,
question.
my lord.
First that
Please, my
question.
lord, please.
Yes.
Property or the purchaser of any such property sold in execution of a decree is resisted or obstructed by any person in obtaining possession of a property, he may make an application to the court complaining of such resistance and obstruction.
That has
ಅವ್ರದ್ದು
been-
application maintainable ಇಲ್ಲ.
No, that has been considered by the Supreme Court
Yes,
said,
yes, my lord, I have the judgment also that.
which is that
Yes, my lord.
Supreme Court said,
Yes, my lord.
any person can file this thing by claiming.
Who
a
is
right. That
interested
there, but
over the property in question.
that has all decided, that the application will be decided, let them decide by.
And
Yes, that has been
ಬಹಳಷ್ಟು
decided.
facts they have
Go and
not
agitate
disclosed,
in
my
that
lord.
application.
Yes,
have
my
not
and
disclosed
my
before the
liberty
court.
may be reserved as to agitate the
No, my lord.
case before the executing
That
court.
application you have already filed.
Already filed and pending consideration.
One submission, my lord. My suit is decreed based on the partition deed. 1 minute, my lord. My lord.
Partition deed ಮೇಲೆ ಇವ್ರು ಏನ್ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರ ಅಂತ
RA
ತೋರಿಸಿದ್ರೆ
dismiss, they have suffered the orders throughout, my lord.
ಅದಕ್ಕೆ ಏನ್
RA
ಮಾಡ್ಬೇಕಮ್ಮ
dismiss
ನಾನು?
ಆಗಿದೆ.
ಪಾರ್ಟಿಷನ್ ಅಷ್ಟೇ ಹೇಳ್ತಾರೆ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಏನಾಯ್ತು ಹೇಳ್ತಾ ಇಲ್ಲ.
ಅದಕ್ಕೆ ಏನ್ ಮಾಡ್ಬೇಕು?
Subsequently
ಡಿಸ್ಪೋಸ್
ಏನಿದೆ?
ಮಾಡಕ್ ಬೇಡವಾ ಹೇಳಿ?
ಅಲ್ಲ, for a moment, 56 page number.
ಏನಕ್ಕೆ ಹೇಳಿ?
ಅಲ್ಲ, how my partition
I'm
deed
going to
is.
dismiss this case
Yes.
and saying that to
Please, my
agitate
lord.
there.
Please, my lord. Please.
ಏನ್ ಕೇಳೋದಿಲ್ಲ,
Obliged,
ಸುಮ್ಮನೆ ಆರ್ಗ್ಯೂ ಮಾಡ್ತೀರಾ ಸುಮ್ಮನೆ.
obliged, obliged, my lord.
Yes. Let him agitate this application
Please,
under filed under Order 21 Rule 97.
Please,
Yes.
my lord. Please.
Application
Please,
under filed under Order 21 Rule 97.
Please,
Yes.
my lord. Please.
That he has in a right. Even in that he can seek for an stay also for execution. He can do it. Yes, tell. ನಿಮ್ ಗಲಾಟೆಗೆಲ್ಲ ನಾವು ಮೈಕ್ ಹಾಕಿಲ್ದಾನೆ
ಮೈಕೆ ಬೇಕಾಗಲ್ಲ.
My lord, they have misled this court, my lord. That is the reason I am pointing out. That's all, my lord.
ಕೂಲ್ ಇನ್ ದಟ್ ಕೋರ್ಟ್ ಅನ್ನೆಸೆಸರಿ ಸುಮ್ಮನೆ ಯಾಕೆ ರೈಸ್ ಮಾಡ್ತೀರಾ? Yes. ನೀವು ಕೇಳ್ತಾನೆ ಇಲ್ಲ, ನಾನು ಹೇಳ್ತಿರೋದು ಕೇಸ್ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ ಅಂತಂದ್ರು ನೀವು
Please, my lord, I
ಅಂತೀರಾ. ಅವ್ರು ಅದನ್ನ
apology.
ಬಿಟ್ಟು ಮೇನ್ ಮ್ಯಾಟರ್ ಆ ಸೂಟ್ ಮೇಲೆ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾರೆ ಇಲ್ಲಿ. Yes.
ಇಲ್ಲ,
How they are misleading the court that we don't have any registered deed.
Yes, tell.
ನೆಸಸರಿ ಪಾರ್ಟಿ ಮಾಡಿದ್ರೆ ಇದೆಲ್ಲ ಸಂಬಂಧನೇ ಬರ್ತಾ ಇರ್ಲಿಲ್ಲ.
In this writ petition, The degree holder has filed an execution petition in
No,
execution.
ಆರ್ಯ ಆಯ್ತು ಸುಮ್ಮನೆ.
ಆಯ್ತವಲ್ಲ ಕನ್ಫರ್ಮ್ ಆದ್ಮೇಲೆ ಸೇವ್
ಹಾ,
ಬಿಡಿ.
ಸರಿ.
Yes. Execution petition in execution number 32 of 2024. In said execution petition, the degree holder has filed an application under order 21 rule 32 read with 151 of CPC seeking police protection for implement of judgment and degree dated 8/8/2023. The application is allowed by impugn order dated 10th March 2023. The petitioner herein claims to be that they are in the possession of the property and they have filed this petition challenging that order. Since degree is against that one Sri Rudrash, the judgment and degree is only in respect of bare injunction. To implementing that degree, IA has been filed. Accordingly, the application filed under order 20.
In accordance with last case.
ಈ ಕೇಸಲ್ಲಿ you have no right at all.
In accordance with last case.
ಈ ಕೇಸಲ್ಲಿ you have no right at all. ಏನೋ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಕೊಟ್ಟಿದ್ದೀವಿ. In the meantime, you could have go there and approach either filing a suit or agitating your order 21
Objector
rules.
application ಅವರು ಮೂನು ಮಾಡ್ಕೊಂಡಿಲ್ಲ. That was filed subsequent to
ಮೂವ್ ಮಾಡಕ್ಕೆ
the
ಸ್ಟೇ ಇದೆಯಲ್ಲ.
Yes.
caveat ಹಾಕಿ.
All pending applications are disposed.
P group matter, serial number
Obligation.
48, 49 urgent, serial number 50, PB Raju for petitioner, PL Sanjeev. Serial
Yes.
number 50, PB Raju.
Yes, none appear. Reach this matter after vacation.
Serial number 51, Raghunath MD for petitioner, VB Shivakumar.
I appear for the petitioners.
Pass over. He is not there.
I understand, my lords,
Or any other date.
but there's some urgency before in the honorable trial court. They're posting day after day, my lords.
Now we will have it Monday or Tuesday.
And only humble submission, my lords. It'll be a personal inconvenience for me.
Hmm.
I'm getting married, my lords.
Oh.
That is why I cannot be there from Monday, my lords.
When is that marriage?
It's on the 30th, my lords. But from Monday, I won't be in town, my lords.
After vacation.
But if I may seek for today, my lords,
Same ground you urged before the trial. court. Definitely will get it that.
I shall do.
The court below has accepted the report filed by the, has accepted the report filed by the FSL expert.
Hmm.
Admittedly, who is not an expert, my lord. Thereafter, I preferred an appeal.
Watch that, sir. Appeal. Now, what is the suit for?
Suit for a specific performance,
You are the plaintiff or a defendant?
plaintiff, my lord.
Plaintiff.
Suit lower court ಅಲ್ಲಿ dismiss ಆಯ್ತು, ಸುಮ್ಮನೆ appeal ಬಂದು.
Appeal ಅಲ್ಲಿ ಏನಾಯ್ತು?
Appeal ನಲ್ಲಿ 3 IA ಹಾಕಿದ ಸಮಯ allow ಆಯ್ತು.
Hmm.
One for leading additional evidence, another for referring the document for finger, another for amendment.
Hmm.
ಅದು ಎರಡು allow ಆದ್ಮೇಲೆ amendment carried out and additional evidence ಆಯ್ತು ಸಮಯ. ಈಗ FSL expert report ಏನಂದ್ರೆ
Rejected.
allowed,
Huh.
FSL has filed the report that is
That application is allowed.
yes, my lord.
Report is obtained. Now you are updating that report.
Yes, my lord.
Why?
Why,
Then
my
you
lord?
ask for a report? You only ask the report.
His own application.
No, my
alone.
lord, no, my lord, it is my, as of
As
my,
long as report has to come to in your favor, you are go on challenging.
no, my lord, that,
In your favor, you are go on challenging.
no, my lord, that does not mean it is leave, I leave it to your lordship.
Hmm.
Kindly see the cross examination of the person who is admitted to be the expert.
Hmm.
At page,
ಏನಕ್ಕೆ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರಿ?
FSL ಇದಕ್ಕೆ two agreement of sale ಮೇಲೆ
P1 and P2 ಏನ್ ಸಿಗ್ನೇಚರ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದ್ರಾ?
signature LTM ಎರಡನ್ನು signature with LTM.
LTM ಅದನ್ನ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದ್ರು.
ಹೌದು ಸರ್.
Now report says that that is not their signature.
Yes madam. MSc PhD ಪದವಿಯನ್ನು ಪಡೆದಿರುತ್ತೇನೆ. ನಾನು ನ್ಯಾಷನಲ್ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಫ್ ಕ್ರಿಮಿನಾಲಜಿ ಅಂಡ್ ಫಾರೆನ್ಸಿಕ್ ಸೈನ್ಸ್ ನವದೆಹಲಿಯಲ್ಲಿ 3 ತಿಂಗಳು ತರಬೇತಿಯನ್ನು ಪಡೆದಿರುತ್ತೇನೆ. ನಾನು ಫಿಂಗರ್ ಪ್ರಿಂಟ್ ವಿಚಾರಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಯಾವುದೇ ಪರೀಕ್ಷೆ ನಡೆಸಿ ವರದಿಯನ್ನು ನೀಡಿರುವುದಿಲ್ಲ. ದಟ್ ಇಟ್ ಸೆಲ್ಫ್ ಸಫಿಷಿಯಂಟ್ ಟು ರಿಜೆಕ್ಟ್ ದಿ ರಿಪೋರ್ಟ್.
ಅವ್ರಿಗೆ ರೆಫರ್ ಮಾಡಿದಾಗ ನೀವು ಸುಮ್ಮನೆ ಇದ್ರಲ್ಲ, ವೈ? Where is that order for reference, order for appointment of the commissioner?
My lord,
it is not produced.
Hereby accepted and considering that part of the records of this identification. Already ಅವ್ರು ನಂಗೇನು ಗೊತ್ತಿಲ್ಲ ಅಂತಾರೆ, ಅವನೇನ್ ರಿಪೋರ್ಟ್ ಕೊಡ್ತಾರ್ರಿ?
no my lord, I would like to
Not on the basis of, he is saying that he does not have a qualification in the FSL ಇದು ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. On the basis that ಅವನು basic degree ಮಾಡಿದ್ದು ಪ್ರಾಣಿಶಾಸ್ತ್ರದಲ್ಲಿ, but he has a expert in that field, my lords.
Which is the degree which required for handwriting? Which is the degree which required for handwriting experts, mister? What is that law?
They have to say, my lord, what is the notification for that effect?
ಎಲ್ಲಿ
he must
handwriting
be a
experts
master degree holder in that particular science, my lord.
ಎಲ್ಲಿದೆ
I
ಅಂತ?
kindly I will read the report, division bench ruling of our honorable court, my lord. Before their lordship Nesargi and Vittal Rao judges, my lord, kindly may read the, if the evidence does not flow from such a witness, then that evidence would be hit by general rule and therefore would it is mentioned that he has experience in the field by itself does not constitute evidence.
ಓದ್ತಾ ಇದ್ದೀರಾ ನೀವು? ಓದೋದೆಲ್ಲೂ ಇಲ್ಲಿಲ್ಲಲ್ಲ.
ಈಗ ಕೊಟ್ಟನಲ್ಲ ಅದು ರೂಲಿಂಗ್ ಕೊಟ್ಟ
First page.
ಫಸ್ಟ್ ಪೇಜ್
ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಏನ್ ಓದ್ತಿದ್ದೀರಿ?
ಫಸ್ಟ್ ಪೇಜ್ ಮೂರನೇ ಪ್ಯಾರಾ.
ಅದು ಹೆಡ್ ನೋಟ್ ಬಿಡಿ, ಅದು
ಹೆಡ್ ನೋಟ್
ಅದು ಹೆಡ್ ನೋಟ್ ಬಿಡಿ, ಅದು
ಹೆಡ್ ನೋಟ್ kindly turn to page there are 7 lord.
Person wherein it is mentioned that he has experience in the field itself doesn't constitute evidence. The evidence should be one that is found that shown statement of the witness.
The opinion of scientific men upon proven fact.
ಎಲ್ಲಿದೆ? ಯಾವ ಒಳಗಡೆ ಓದಿ ಪ್ಯಾರಾಗ್ರಾಫ್ ಫೈಂಡಿಂಗ್.
ಅದ್ರ 7 ಮೇಲೆ
ಹೇಳಲ್ಲ ಅವರು ಸ್ಪೆಷಲ್ any judgment that he should have any degree on that.
No, ಇವರೇ ಒಪ್ಕೊಳ್ತಾರ?
ಎನಿ ಲಾ ಆರ್ ಜಡ್ಜ್ಮೆಂಟ್ ತೋರಿಸಿ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಎಕ್ಸ್ಪರ್ಟ್ಸ್ ಗೆ ಪರ್ಟಿಕ್ಯುಲರ್ ಡಿಗ್ರಿ ಇರಬೇಕು ಅಂತ.
ಸೆಕ್ಷನ್ 45 ದಲ್ಲಿ ಸುಮ್ಮನೆ
ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್.
I would like to conclude this, my lord.
ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅದಿಲ್ಲ.
ಇಲ್ಲ, PW 7 ಅಲ್ಲಿ ಪ್ಯಾರಾ 7 ಸುಮ್ಮನೆ has nowhere stated anything about his experience in that particular branch. Or he had made a special study of the subject of assaying gold so as to make him skilled in that branch.
ನೋಡಿ ಅಲ್ಲಿ ಏನಾಯ್ತು? he had not made any special studies of that subject of assessing the gold so as to make him experience ಇಲ್ಲ ಆ ಪರ್ಟಿಕ್ಯುಲರ್ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ. ಸ್ಪೆಷಲ್ ಸ್ಟಡಿನೂ ಮಾಡಿಲ್ಲ ಅಂತ. ಇಲ್ಲಿ ಸ್ಪೆಷಲ್ ಸ್ಟಡಿ ಮಾಡಿದ್ದಾರೆ. ಆ ಕೇಸಿಗೆ ಈ ಕೇಸಿಗೆ ಇಫ್ ಯು ಟೇಕ್ ದಿಸ್ ದೆನ್ ಇಟ್ ಈಸ್ ಎನಫ್ ಅನ್ಲೆಸ್ ಯು ಶೋ
ಕ್ವಾಲಿಫಿಕೇಶನ್.
ನೀವು ವಕೀಲರೇ, ನೀವು ಫೊರೆನ್ಸಿಕ್ ಎಕ್ಸ್ಪರ್ಟ್ಸ್, ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಎಕ್ಸ್ಪರ್ಟ್ಸ್, ದಿಸ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಡಿಗ್ರಿ ಇಸ್ ರಿಕ್ವೈರ್ಡ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಐದರ್ ಲಾ ಆರ್ ಜಡ್ಜ್ಮೆಂಟ್ ತೋರಿಸಲಿಲ್ಲ ಅಂದ್ರೆ ಇಟ್ ಸೇಸ್ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಇದ್ರೆ ಸಾಕು ಅಂತ ಹೇಳ್ತಾರೆ. ಆರ್ ಹಿ ಹ್ಯಾಸ್ ಸ್ಟಡಿ, ಸ್ಪೆಷಲ್ ಸ್ಟಡಿ ಆಫ್ ದಟ್ ಸಬ್ಜೆಕ್ಟ್.
ಕೊಡ್ತೇನೆ ಸರ್, ಮಂಡ್ಯ ಕೊಡ್ತೀನಿ.
ಕೊಡಿ, ಯಾವ್ದು ಕೊಡ್ತೀರಿ?
ಮಂಡ್ಯ ಕೊಡ್ತೀನಿ.
ನಾಟ್ ಮಂಡ್ಯ.
93 minutes.
Not to precipitate ಅಂತ.
ಎಲ್ಲಿ ಸೂಟ್ ಯಾವತ್ತಿಗಿದೆ?
23
That's 93 suit ಇದು ಹರಿಹೆ ಹಾಕಿ.
ಆಯ್ತು, ಯಾವತ್ತಿಗಿದೆ ಸೂಟು?
23 ತಾರೀಕಿದೆ ಸ್ವಾಮಿ.
ಇವತ್ತೆಷ್ಟನೇ ತಾರೀಕು? ಇವತ್ತೆಷ್ಟು ಡೇಟು?
ಮೂರು
Fourth ಸ್ವಾಮಿ.
ಮೂರು
24.
ಮೂರು ಸಾರಿ 3/5
ಒಂದು ವರ್ಷದಿಂದ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ, ಒಂದು ವರ್ಷದಿಂದ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
ಎಷ್ಟಕ್ಕಿದೆ?
3/5 ಸ್ವಾಮಿ.
3/5
ಹಾ ಸ್ವಾಮಿ.
ಎಸ್ 3/5 ರಜೆ ಬರುತ್ತಲ್ಲ, ಲಾಸ್ಟ್ ವರ್ಕಿಂಗ್ ಡೇ, ಏನೂ ಆಗೋದಿಲ್ಲ. ಇನ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ವಿಲ್ ಸಿ ಆನ್ ದಟ್. ಎಸ್.
Cell number 53, Rajshekhar as per petitioner, connected matter, K. Prasanna Shetty.
ಎಸ್ ಮಿಸ್ಟರ್ ರಶ್.
Let us go in respect of one temple melody which is being run by our family from 1940 melodies. I am before melodies.
Where is your opponent?
Kindly see melodies. Trial court rejected the application. IA2 was filed by the plaintiff melody. The suit is one, defendant is before melodies.
Is there an interim order?
But entry order status ko anteli ಇದೆ.
We will have it after vacation. He is not there. Yes. None appear. Here again. No, status quo has been granted.
Status quo has been granted.
Then where is your opponent? Read this matter. None appear for the respondent. Read this matter on 4th June. Let us see.
For interim order till then, interim order
ಕೊಟ್ಟಿದ್ದಾರಾ ಈಗ ಇದೆಯಾ?
ಇಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ ಅದಕ್ಕೆ.
Then I have to hear him. That's why. Otherwise, I could have hear and dispose of.
Serial number 54, Mohan Kumar HG for petitioner, A. Keshava Bhatt.
I appear for the petition in this matter, my lordships.
Yes.
My lordship to page 23, my lords. Sorry, 22. Of the writ paper.
Yes,
In
he
the
is not
second
there. Pass over.
Highly obliged, my lords. Kindly it may be passed over.
Pass over. Yes, yes.
Serial number 55, Chandrasekhar P. Patil for petitioner, Balaram ML.
I appear for the respondent.
I am for petitioner in this case, my lord.
Yes.
The impleading application filed by the petitioner is rejected, my lord. The plaintiffs have filed a suit, my lord, directing the respondent to construct the property as per the in accordance with law.
Where is that?
During the
claim?
pendency of that proceedings, my lord, the property was sold to this petitioner, I mean impleading applicant. The impleading applicant has filed IFR impleading. The saved application, my lord, is rejected on the ground that the plaintiff is contesting the suit, my lord. Your lordship will get it to page number 16, my lord. Running page 16.
No, where is the plaintiff?
Client, my lord, it is annexure C, page number 24. And prayer is at page number 27.
Declare that.
Declaring that the act of defendant number 1 is taking up construction at points A, B, C, D in his property without leaving the points A, B, C, D in his property without leaving the setback or marginal
Their
place of
allegation is that
3
you
feet
are
towards
constructing.
injunction. During the pendency of the suit, my lord, the plaintiff number 1, represented by a GPO holder, plaintiff number 2, have sold the property in favor of the impleading applicant.
You have
As
purchased
per the, I am the purchaser. I have produced annexure D and E
after
are
filing
the-
the suit.
after filing the suit. During the pendency of the suit, my lord.
Yes.
After filing the suit, after purchasing, my lord, my name is included in the property extract and I am the owner of the property.
You filed
Therefore,
an impleading.
I filed an impleading application to implead as plaintiff number 3 in order to proper contesting the matter, my lord. Because after selling the suit property, the plaintiff number 1 is himself opposed and he says
Now,
that
who
he
has
has
sold
not.
that? Who has sold that property?
Plaintiff number 2, my lord, GPA holder. Plaintiff number 1 has executed a GPA holder in favor of plaintiff number 2,
No,
Now
GPF for
selling the
only,
property. Please.
contesting the case or selling the property also?
Selling the property. Selling the property.
Then
On
why
the
he
basis
has
of that,
objected?
my lord, that's what, my lord. Now, on the basis of his objections, my lord, now the application is rejected by holding, my lord, para number 5, page number 16, my lord.
Where is that?
Page number 16.
Para number?
Page number 17, para number 6, my lord. Upon careful consideration of the rival contentions, I am of the opinion that, as rightly contended by plaintiff number 1 and the defendant number 1, the proposed plaintiff has not made out any grounds to implead him as a plaintiff, since the first plaintiff has denying the genuinity of sale deed executed by the second plaintiff, being a GPA holder of the first plaintiff. He has not challenged the sale deed even today, my lord.
It is challenged.
And subsequently he might have. His interest will not be affected. Further, the first plaintiff being a title holder of the scheduled property at the time of filing of the suit is seriously contesting the suit. She is not acting adverse to the best interest of suit scheduled property. In fact, she is denying the genuinity of the sale deed. Moreover, if the applicant is permitted to come on record as a plaintiff, the interest of the plaintiff number 1 and the first proposed plaintiff will become adverse to each other. Further, the plaintiffs being a dominus litis have a right to select the persons against whom they have to seek the reliefs for the reasons stated herein above collectively.
He himself is objecting that sale deed. If he is not objecting, then he will step into the shoes of that plaintiff. But he is objecting the plaintiff, then
No, merely because objecting the execution
Mr.
of sale deed will not.
procedure of the suit
Please.
has to be decided between plaintiff and defendant.
Please.
Here it will be dispute between the plaintiff and
Plaintiffs.
plaintiff. That cannot be a law, mister.
Yes, sir.
That is what they said. You file in a separate suit.
Yes.
Separate suit is a different aspect, my lord, because the suit is
No, your sale is objected by the very same plaintiff who has filed in a suit. Who filed in a suit, he said that I have paid in a court fee. I don't want him. You can't say that I will be. If you have any grievance, you file in a separate suit. That is what the law, mister. That is what trial court also consider. You file a separate suit.
my submission is
Otherwise,
made as
ನಾಳೆ
a,
ಇನ್ನೊಬ್ಬ ತಗೋ ಬರ್ತಾನೆ ಸೇಲ್ ಡೀಡ್ ಬರ್ಸ್ಕೊಂಡು ನನಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅವನು ಇಂಪ್ಲೀಟ್ ಮಾಡ್ಕೊಂತ ಹೋಗ್ತಾ ಇರೋದು ಆಗಲ್ಲ.
ಅಲ್ಲ,
Plaintiff
till
himself has
the
denied.
sale deed is in existence, my lord, I am the owner. He might have challenged that sale deed,
If
but
you-
so long the
No,
sale deed
mister,
is there.
If you are owner, if you are confident that sale deed is in accordance with law, go file in a suit. You file a separate suit. Who will stop? You have to pay the court fee and seek for this thing. Then both the suit will be clubbed together. If
This-
that is a similar matter.
With that observation.
This suit
Not
will become,
observation, you file it that.
this suit will become inter-se plaintiffs, contest between plaintiffs.
That cannot be that.
Yes.
If you want, you can agitate by filing a separate suit.